Okay, if people are ready, we'll make a start. All good? Okay. First thing to say is thanks to the speakers for taking time to come and talk to us, and for everyone who's here for joining in. A couple of things to say first is to acknowledge a couple of people behind the scenes here. Claire Fitzgerald, that people should know, is one of the policy officers for the Just Transitions, who's done all the organising basically on this. Ben Ryan is back there doing technical work. I hope he's there. I haven't seen him, but you know, he should be out there twisting knobs and things. Louis Gribben-Burke is here, who actually started us off thinking about this and is really the person in the Just Transitions at the moment, kind of coordinating the intellectual effort on the this consultation, we'll say. And then Aisling Kiley was also involved in the organisation of this, kind of as the, I'm going to say, quiet power behind it all. My name is Barry Begley. I'm a Just Transitions member who got thinking about these things, these issues, with regard first to how the planning process works in Ireland. And then again, when the forestry bill was happening back in August and September. And so then just recently, when Louis told us about this Department of the Environment consultation, I saw a chance to do a little bit of thinking. So here I am tonight. First thing to say is that thanks to Ben Ryan's efforts, this is being live streamed, I hope, on the Just Transitions YouTube channel, and is also going to be recorded and put up on that channel, as I understand it. Secondly, there is a form being put in the chat by Claire, I think, for people to fill in if they're interested in other events we might be holding on access to information on the environment. So what are we doing here tonight? We're trying to work out primarily, or the kind of basis of it was how best to respond to a public consultation process which has been set up by the Department of the Environment, Climate and Communications. That consultation, which is running until mid-April, April 16th, I think, is a review of the Irish regulations on access to information on the environment, statutory instrument from 2007. Those regulations are meant to give effect in Irish law to an EU directive from 2003 on public access to environmental information. And that directive from 2003, that EU directive, is meant to bring EU law into line with the Aarhus Convention, a convention from 1998 on access to information, public participation in decision-making, and access to justice in environmental matters. So we have these Irish regulations, which are our focus at the minute on this consultation process, an EU directive, which the Irish regulations putatively transpose, and the Aarhus Convention, which that directive is meant to give effect to, all supposedly aiming at the same thing: easy public access to information related to the environment in the context of public participation and access to justice in environmental matters. Okay, so far so good. And then, just in December, we had a complaint heard at the Aarhus Convention Compliance Committee in Geneva, arguing, and the committee largely agreeing with them, that Ireland's regulations do not properly give effect to the Aarhus Convention. Hence, as I understand it, this need to review the Irish regulations and this consultation by Eamon Ryan's department as a response to that decision, at least in part. So this event tonight really has two aims. One is focused on that consultation and the submissions that people, everybody, can make to the Department of the Environment. So what we want to do is hear from people who can help us better understand the Irish regulations, why they matter, how they work, how they could be improved, or what about them is actually working well. And we also want to help spread the word in its own right on the importance of access to environmental information for the sake of public participation and access to justice, and what's at stake in all of that. So I think we have as good a panel of speakers on this topic as one could probably have. Each of them will be quite well known to many people here, but I'm going to introduce them anyway. First speaker tonight is Ciarán Cuffe. He's a Green Party MEP for Dublin. He previously served as Minister for State for Sustainable Travel, Planning, Heritage, Horticulture in 2010-2011. And in the European Parliament, he's the President of the European Forum for Renewable Energy Sources. He's a man who knows about European environmental policy and how it ought to be given effect in Ireland. Second speaker tonight is Attracta Bhroin. Attracta Bhroin is the environmental law officer with the Irish Environmental Network, which is basically the gathering of the environmental NGOs in Ireland. People will know Attracta also as someone who was engaged from early on in the issue of the CETA ratification and its effect on access to justice, but she's also someone who's been long working on the issue of public participation in the planning process in Ireland, for example. She's vice president of the European Environmental Bureau, a network of major European environmental NGOs, and she is, or at least was, I'm not sure if she still is, a member of the Environmental Law Implementation Group, a joint initiative with the Irish government and NGOs, whose objective is to support the proper transposition and implementation of environmental law, which actually couldn't be more on point. And I think, unless I'm wrong, I think Attracta Bhroin was in Geneva as part of the group that was involved in that complaint to the Aarhus Compliance Committee, and she'll tell us if I'm right about that later on. And the last speaker tonight, Niall Sargent. Niall Sargent is a journalist with the journal.ie, editor of the Green News and of Noteworthy.ie, a platform within the journal doing actual investigative journalism and also democratically funded, which is actually a really great initiative from both sides. His work isn't only on environmental topics. He did work on, for example, on reporting from the West Bank not so long ago, but he really is a muckraker on environmental issues, and we need a lot more muckrakers in Ireland, to be honest with you. Anyway, he's a man who's well placed to know about the importance and problems of access to information on the environment. That's the three speakers. How this is going to work is each person will speak for 15 or 20 minutes maximum. People can put their questions in the chat. If they do want them to address to a specific person, point that out in your question. And at the end, we'll have time for Q&As, selecting questions. Maybe not every question will get asked, but we'll do what we can. If that's all okay, our first speaker, Ciarán, over to you. Thanks very much.
Thanks very much. I don't know if Claire got my slides and if she could share them. That's brilliant.
I'll just get them up now.
That's great. So look, I think you've already covered a lot of what I want to say, and you know, my apologies in some respects, insofar as this is a topic I used to lecture on when I was teaching urban planning in Dublin Institute of Technology, now TU Dublin. So it's probably a little bit of a dry presentation, but I'm just going to fly through a few slides. Do I have 5-10 minutes? How are we fixed time-wise?
Absolutely, yeah, 15.
Great. No, well, I'll try and keep it short because it can sometimes be a little bit dull. So that first slide, which I don't see, I see a lot of blank screen, but actually the first slide was just a picture of Denmark showing you where our house was, because some of you might not know that Aarhus is a small city on the east coast of Denmark. I think about 100 miles up from Copenhagen, and there's been some good conferences there over the years in cities like that. And of course, the Danes, you know, they're good on thinking ahead and planning, and I think they're pretty good at involving citizens in what they do. And certainly for many years, I used to talk about the urban plan for Copenhagen, which was in the shape of a hand with fingers, and they basically had rail lines and they put the development close to the rail lines, and they got it right over half a century ago, and to many extents they're still getting it right today. So Claire, I don't know if my slides
no, sorry about that. I'll just try again. That was me.
That's okay. That's fine. Actually, whenever I do screen sharing myself, I always seem to make a hames of it. So it's nice to know I'm not alone.
Are we any better now?
That's better. And if you could go to full screen by maybe just at the bottom, you can see maybe 4 options next to the plus minus, but the right hand one there should bring you to full screen, just to the left of the minus, if you follow me. That one, yeah, that's it. And if you could go back one slide, back again. We went a few slides. Yeah, so that was just the first slide, showing you a little bit of a view of Denmark, where Aarhus is. The second slide just gives you a timeline, because look, the Aarhus Convention is about involving citizens when it comes to environmental decisions. And the Aarhus Convention didn't come out of nowhere. Going back to 1972, there was a big conference on the environment in Stockholm, the first one. I vaguely remember it. I was, I think, 9 years old, and my dad went to it to talk about Irish travellers because he was working for a local authority back in Ireland. And I remember it being a big deal, a discussion, a global discussion on the environment. And 20 years later, we had the huge Earth Summit in Rio de Janeiro, where amongst many other documents, such as Agenda 21, were passed, which was all about involving local authorities and citizens. There was also the Rio Declaration on Environment and Development. I think 27 principles in total, but I think Principle 10, if I'm right, was led to the Aarhus Convention. And this was approved by the United Nations back in 1998, and I'll go into a bit of detail. That then led to, within the European Union, to a couple of directives. This is the laws that are made at the European level. This is the bread and butter of what Grace O'Sullivan and I do from day to day at the moment. So we had one there about public access to environmental information, another about public participation. And since then, we've seen other developments. We had the big Sustainable Development Goals that came through the United Nations just 6 years ago. And every few years, we see further recognition of the importance of the environment at a global level. So the Aarhus Convention didn't happen in isolation. And even now, here in the European Parliament, we're proposing a European climate law. Why do I mention that? Because the climate law sets targets, and if the targets aren't being met, we need to do something about it. And the Aarhus Convention should allow us to hold our governments and institutions to account. Moving on to the next slide. So the convention came from UNECE, which is the United Nations Economic, Commission. I'm about to sneeze. Excuse me, I was just sneezing there. So this is what the relevant UN body and what was agreed at the 4th Ministerial Conference on the Environment for Europe. It's about accountability, it's about transparency, and it's about responsiveness. And it's really important because it is legally binding, and it puts Principle 10 of the 27 principles in the Rio Declaration into practice. 27 principles, I won't go into them in detail, but if you think of the Sustainable Development Goals as being about, 17 or 19 goals, they almost mirror them in terms of involving people and thinking about the environment. So going on to the next slide, you can see that the full principle that had been adopted back in 1992, 6 years previously, was let's get people involved in making decisions about the environment. Let's make sure that they get the right information and that they can participate in the decision-making process. And this sounds, relatively straightforward, but in some countries, Ireland included, it can be very difficult to deliver on all these three issues. So moving on to the next slide, I'm just highlighting participation of citizens, access to information, public participation, and then access to judicial proceedings. If you don't like the decision, what can you do about it? So these are what is involved. Moving on, then, just distilling the pillars of Aarhus down to 3. Remember, you should be able to get the information. You should be able to be involved in the making of the decision. And really, if you're unhappy with the decision, you should be able to do something about it. You have access to justice or an appeals mechanism. The next slide then tells you a little bit about how Europe went about doing this. So we had 2 directives in 2003 covering 2 aspects of it, and then a regulation You know, the same as Ireland, we pass laws in Europe known as directives, and then the government or the European Commission can produce and Council can produce regulations that go into the detail. And there's a lot that you can go through in these regulations, a lot of detail. I know I'm talking very much in legal speak. I'll try to bring it down to bread and butter in a slide or two. But meanwhile, if the first 3 bullet points there are about Europe, the final bullet point there is about Ireland. And these were regulations passed 14 years ago by the Minister for the Environment, regulations, I assume, laid before the Oireachtas in 2007. And that also put in place a Commissioner for Environmental Information who you can appeal to, a bit like the Ombudsman. If you feel you haven't been fairly heard or the law hasn't been appropriately applied, you can go to the Commissioner. Moving on to the next slide. There's a notice on access to justice, which gives a huge amount of guidance about how you can challenge the decisions, the acts or the omissions by public authorities. From my memory, it makes it very clear that the buck stops with the European Court of Justice in Luxembourg. If you have a difficulty with Aarhus, that's where you end up with a court decision from the ECJ. Moving on, just a few slides more. You know, getting the information and having the right to have your views known is relatively easy. What can be a bit confusing is, what is this access to justice? It means you have a right to bring a legal challenge, and the judge at a national level has to look at it in detail and put things right if they agree with the problems you've identified. And also, it shouldn't cost you too much, and they should deal with it in a timely manner. Those last 2 points, the red one and the green one, should actually be in flashing red lights, because that is where difficulties have emerged. Put it very simply, in Ireland, if you don't like a decision that the council or Board Pleanála or the Environmental Protection Agency made about environmental issues, if the only thing you can do is go to the forecourts, look, an awful lot of people can't go next or near the forecourts. They don't have the money, they don't have the access to legal, to lawyers, and also there's a worry about how long it takes to get things processed. So there is a concern in Ireland that we're not dealing with things in a timely manner, to put it simply. And then one last point there, practical information on how to bring a challenge. Put simply, does the Irish government make it easy for you to find out about Aarhus? Does it make it clear what can be done if a decision is inappropriate? And I think we're lagging behind on that front as well. Next slide. One thing I've had fun with, one thing that has really helped me is reading through the Aarhus stuff and working out how can you use one of the points of Aarhus, which is the access to information. And I just have a generic little email that I send off. And in most organizations, the Aarhus officer is also the Freedom of Information officer. Freedom of information can be costly. Aarhus should be free. So generally, it involves an email to FOI at governmentdepartment.ie saying, listen, folks, I want this information, and I understand you may hold it in many different formats. It could be paper files, it could be electronic files, it could be WhatsApp messages if that's an official government WhatsApp channel. And then it's good to say very clearly, this is a European Community's Access to Information on the Environment Regulations 2007 request. It is not an FOI request. That means they can't ask you to fork over 5,000 quid for the documents. And also, you have to be able to get this information within a month. And I try and be as polite as possible. Please do not hesitate to contact me should you wish to clarify. Many thanks, blah, blah, blah. Why am I so polite? Because look, ultimately it comes down to somebody with the godforsaken job of being the FOI officer within that organization. They're human. They do want to help you. They're doing their best. And sometimes I say, look, here's my mobile number if you want to have a chat about it. And I do get emails or calls back saying, listen, do you want to have a chat about it? And sometimes that's a way of getting the information more quickly than being unduly legalistic about it. So for instance, I was trying to find out what lands CIE owned at the back of Euston Station. So I put in an FOI request under the Aarhus Convention, and I ended up having a brilliant Zoom call with the head of the CIE group. Now I know, I'm an MEP, so that makes it a bit easier. But even when I was back, before I was back on Dublin City Council, I found it worked a treat in getting information from organisations, government organisations. Moving on. Then just very quickly, the last few slides. In the European Parliament, we're coming up with a climate law, just in the same way as we're doing that back in Ireland with the publication of the Climate Action Bill yesterday. And moving on to the next slide, this is relevant to our House because we need accountability for climate action. We need to make sure that member states are accountable to their courts, and also we'll have to revise the Aarhus regulation from 14 years ago, which governs access to justice at EU level. You're not reducing the emissions, we want to sue you. And actually there was a great example in the Netherlands quite recently of a court action against the Netherlands that they weren't meeting their targets, and it led to change on the ground. It led to lower speed limits, and I think more controls over agricultural emissions from nitrates. So yeah, having effective remedies is very important. Next slide. As was previously mentioned, there is the ACCC, the Aarhus Convention Compliance Committee, which oversees all of this. And one of the nice things about it is that the vice chair of it is Anya Ryle, and I think she is a lecturer at UCC, if I'm not
just me,
correct.
Or is Ciarán gone missing?
Am I there? Can you hear me?
Yes.
Yeah, we can hear you, Con.
Okay, I think somebody's connection maybe went a bit. So, and interestingly, last year, the Aarhus Convention Compliance Committee heard a group of people from Ireland went there, and the ACCC said that Ireland was not delivering decisions in a timely manner and wasn't giving directions for how to resolve requests that fall within the AIE, within the access to environmental information regulations. So something has to be done about that because Ireland is not in compliance. So moving on, I think I have about 2 more slides. So the duration of time that it takes for the appeals to the Commissioner for Environmental Information has to be considered. There is limited access to the review process for the average Joe blogs. You know, who goes to Board Planola? You have to have usually a couple of €100 in your back pocket, even more if you want to hire professionals. And the courts are even more inaccessible. And so the ACCC, the UN committee that looks at whether we're delivering on Aarhus, said, in a nutshell, we must try harder. And I think that led directly to a public consultation. It may still be open. I thought it had concluded, or maybe there's been a couple of consultations. And this, I hope, will lead to further legislation or regulation in the near future. And then the next slide is just a couple of, further reading, blah, 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 some of the documents I've referred to. And if you want to get the slides from this presentation, there's a bit.ly link at the very bottom, CUF and then Aarhus, and the slides that I have used during this presentation, you can get there. And that's it from my point of view. I know this has been a rather dry, kind of somewhat academic overview of it all. But look, big decisions are being made. The environment is more and more important, and it can be very challenging to get to the decision makers and have your voice heard. And Aarhus should be the way in which your voice is heard and decisions can be reviewed. That's it. Thank you.
Perfect. Thanks very much. And actually, just on two things to say. One is dry and academic is no bad thing. I have to, in my book. And second thing, like as far as I understand, you were talking about the consultation is ongoing. That's maybe there was a previous one that I don't know about, but What we're trying to do is work towards this consultation.
No, that's good, and you're probably right. I didn't have a chance to look at it. It's been a busy day here in Brussels, so I didn't have the chance to do as much prep as I wanted on this.
No, fair enough, fair enough. Listen, thanks very much. Okay, without further ado, Attracta, Bhroin, are you there? I think we've lost Attracta, have we?
No, I'm here. I'm just going to try and share my screen.
Okay, perfect, thanks. Okay, over to you.
I won't switch on my video until it's hopefully up there, so you won't see my face panicking if it doesn't appear. Can you see that?
Yeah.
Okay. First of all, thank you very much for the opportunity to talk to everyone about this really important consultation. Unlike Ciarán, I don't think it's dry at all. I think it's fierce exciting stuff, but maybe that's just because I'm dry and a nerd. And just to clarify, just in relation to the very warm and generous introduction that I got from Begley, his reference to ELIC is effectively a project initiative with which I work on. So I hope that just clarifies it for people. Basically, I've been asked to talk about the Irish regulations and the driver for the public consultation. And we got a very comprehensive overview, particularly from Barty's introduction. But I'm conscious that there may be a lot of people who are either coming a little bit late into the session this afternoon and indeed listening to it online that may not be as quite as familiar. And that's really the approach that I've taken in this, because in the context of the 20 minutes or so that I've been asked to talk, it's not going to be really possible to go into a lot of technical detail about what is right and wrong with the regulations, because for some people listening, they won't even understand what the fundamental process and what is actually intended to be delivered, even at the highest level, without getting into very technical legal arguments. So I've pitched it very much at sort of the broader public, because I actually think, particularly for the people who are most expert, they are the people that we most need to ensure are addressed in the changes to the regulations. And I'm very conscious, looking at some of the participants tonight, we have some really, really expert people here. So just moving on from that, what I'd just like to say is, if you're a member of the public and you've heard about this consultation and you start Googling and you come to the sort of the general page and introduction on the Cuffe.ie website, you'll see that basically, exactly as has been set out here, that it's partly driven by a response to the findings of the non-compliance by the Aarhus Convention Compliance Committee. So we think, oh, that sounds interesting, Ireland's in trouble over something and has to do something and is doing something. That's all really positive. And that they're actually going to use the review to consider further updates. So generally that all sounds very encouraging, and I would have to say, in general terms, would have to be welcomed. So then moving on to click on the refer to consultation document, which one would hope would help you through this whole consultation process. The information that it provides is very much repeating that reasons for the review at the start, and then it talks about the AI regulations form part of a legislative package that implements the first pillar of the Aarhus Convention and transposes the AIE directive in Irish law. Now, if you didn't have the very helpful introduction that we've all had this afternoon, where does that leave you as a member?
Attracta, I might break in for 2 seconds and ask, I don't know if it's possible to someone put in the chat, can you share that on full screen so that people can see it more clearly? I don't know if you can or not, but I don't know how you would do it. Maybe someone's more expert than me, but
is that better? Is that clearer?
Yeah, that's perfect.
Yeah. I beg your pardon, sorry about that. I'm just nervous. I always get nervous with these wretched Zoom things. So basically, if you didn't have the benefit of the introduction that we've had this evening, and you're just looking at this Aarhus Convention transposes AIE directive, what's all that about? And this is one of the fundamental things that I think we need to look at in terms of how this consultation has been orchestrated. There's no link to the Aarhus Convention. There's no link to the AIE directive. Then it lists a whole pile of regulations, and effectively you have to get out your knitting needle, because some of these actually change words, phrases, and strike through whole clauses. So effectively you don't even have a consolidated version. So very quickly people might actually start to lose heart. just even in terms of just trying to navigate. And we're only on section 3, sort of the second paragraph of this sort of document, or the second and third paragraph of the document. Then there's a further 4.5 lines on the content of the regulations. And then section 4, termed consultation document, really is about, you know, who to send this to, the email or the postal address and the closing date. Then there's a section on data protection, and then follows 3 questions. And these are the 3 questions. What, in your opinion, are the positive benefits of the AIE regulations? Should any specific part of the regulations be amended? And you're asked to specifically address your responses to the technical articles in the regulations. And then question 3 is any other comments? And then right at that very end, then we actually have a link to the directive. And I have to say, I personally don't think that's a particularly inspiring start. There's no details on the issue of non-compliance with the Aarhus Convention, no details of where you might even go to look or understand what that's all about, or why, you know, what actually has been found to be non-compliant. How expansive is it? How narrow is it? No link to the convention or an explanation of what it is or how it relates to these regulations. No link to the directive until the very end. Linked to 5 different sets of regulations. No mention of the really important cost protective provisions if you end up having to go all the way to the court to vindicate and to pursue access to justice for your request. No link to the unofficial consolidated version of the regulations, which in fairness the department has produced with a broad caveat around its legality. And engaging with the 3 questions for many is going to be really difficult. And that slide in the bottom is just to give you a sense of what the consolidated regulations look like, you know, with bits struck through, bits replaced, which is an awful lot better than actually having to try and actually work that out yourself by drawing together 5 different sets of regulations. But if you didn't even know it was there, you might be very despondent. So for an ordinary member of the public, it could basically result in a feeling like this gentleman in the bottom right-hand corner of the screen. And what I want you to do now is, you know, particularly for those of you who may be less familiar with this, is to write down your answers quite seriously to this poll. And I'd ordinarily try and do this live, but I don't think we're going to have the time to do that. But in terms of how able did you feel you were going to be able to engage in the consultation up to now? How much do you know about Aarhus? How much do you know about AIE? Have you ever made an AIE request? Why not? Is it because you think there are costs involved? You don't know how to, you've heard horror stories, you've better things to do with your life than saddos like me and Niall? Have you made an FOI request? Why did you make an FOI request instead of an AIE request? Have you done both? Have you never done either? If you've made an AIE request, was it for you? Was it easy? How was it for you rather? Was it easy peasy? Was it hard? No idea, never again? Or are you a believer? And I think those questions are actually really important to telling us about the experience of the implementation of the Aarhus Convention and the Access to Information on the Environment Directive, and particularly for the wider public. And what I want people to do is, particularly the experts who are coming to this with, you know, very anxious to argue very complex legal arguments around why this provision isn't right or why that provision isn't right, is not to forget about that broader experience, which I think is incredibly important in terms of what this means for the wider public. Now what I'm going to move on to is the overview, I suppose, which is the legislative context, a lot of which we've touched on, so I'm going to speed through that at a rate of knots. And then I'm going to touch on what's wrong and to be improved. I'm going to specifically talk about the compliance issue that was decided upon by the Aarhus Convention Compliance Committee, and I'm going to touch on some other considerations, some of which I'm very glad to say Barty mentioned at the start. So where does AIE come from? And this is, I'm going to fly through this because Ciarán has touched on a lot of this. Basically, like many good things, it came from Rio ultimately. I will leave you with the Principle 10 Rio Declaration on the slide there, because it is really rich. Each individual shall have appropriate access to information concerning the environment that is held by public authorities, an opportunity to participate. States shall facilitate and encourage public awareness and participation by making information widely available and effective access to justice and administrative proceedings, including redress and remedy, shall be provided. This was quite breathtaking at its time. This was really, really important to enable and empower citizens. So what it ultimately gave rise to was a human rights convention. And I think that's really important to emphasize, because a lot of people think about Aarhus as being something around environmental decisions and that it's an environmental thing. It is actually a human rights convention. And that is nowhere more clear than in Article 1, its objective. It's about the protection of the right of every person of present and future generations. It's a really uplifting statement, and every line of the whole of the convention and the subsequent directive that it gives rise to in the European Union needs to be read and interpreted in the basis of that very powerful objective in a purpose of interpretation. And the three pillars that it gives rise to in terms of access to information, public participation, and access to justice, I personally hate the term pillars because it sounds like they're three distinct things, but the whole idea is they're supposed to be mutually supporting so that you are empowered and inspired to engage, or indeed motivated through worry to engage, because you have access to information on the environment, to then participate in decision making, and you can do so in an informed way. And if there are issues with the decision, that you are empowered to pursue access to justice, and in a way that it's not just a right that you can't touch, like, you know, a Ferrari that you can't access because you don't have the keys, but the characteristics that are required in terms of not a prohibitive cost, that it should be timely, it should provide for adequate remedies. It is a really, really rich convention. So some of the key bits of the information pillar, they're scattered throughout. A lot of people just jump into Article 4 and they think that's all about access to information. But I would encourage you to read the convention. It is actually really readable and it's quite short. And every time you read it, you will get more from it. And basically from the objective through to the definitions, which define the type of information that you can have, and what are the authorities that basically are that are obliged to provide the information, etc., and do their duties under it. There are general provisions in terms of broad obligations on the member states to implement this effectively. And then there's the specifics around access to environmental information, and very particularly Article 5, which very often gets glazed over, around collection and dissemination of environmental information. Too often the focus is just on the request process. And I think we forget, and I will repeat this later in this presentation, we forget that basically proactive dissemination of information should be the norm, and the request process, in effect, should be the exceptional requirement that we are obliged to have to pursue if the information isn't immediately available to us. And then, of course, is the incredibly important access to justice. So what does that all mean for you, EU legislation and Irish legislation? I'm going to skip through this because we have sort of really touched on it to quite an extent. But the EU ratified the Aarhus Convention in 2005, and Ireland ratified Aarhus in its own right in 2012. And that means, in effect, that effectively we have two things coming at us. We have an AIE directive and we have the convention, and we need to make sure that we comply with both, because in some instances there are broader obligations in the directive than there are in the conventions, and better ones. And in other instances, the directive is inadequate in relation to some aspects of the convention, or some might argue that to be the case. I think it's also important just to emphasize that the term regulation has caused some confusion, because as Ciarán referred to, there is a change to the Aarhus regulation at EU level, which is the EU's obligations in respect of Aarhus, as opposed to the regulations, which is the statutory instrument, which is the national level of access and implementation that we have at the member state level and here in Ireland. Basically, what do we need to do to improve? In transposing and implementing the convention and the directive, a number of technical legal issues have arisen that, you know, I'm not going to go into in a lot of detail today, because I think, you know, people will need to understand exactly fully what the request process was and all of the different elements and definitions. and we wouldn't simply just have time to do that today. But I am going to touch on the specific issue of non-compliance with the Aarhus Convention and very hopefully give you sort of a flavour of what a request and what the process is, a bit like in the process of doing that. And then very much emphasise it's not just about processing access requests, and that is exceptional. But bear in mind that really when you look to how adequate Ireland's implementation is, that when you're talking about AIE is on the left-hand side, because in interpreting the adequacy of what we have done, you need to look through jurisprudence of national courts, of the Court of Justice. You need to look at our AIE regulations. You need to look at the AIA Directive. You need to look at the Aarhus Convention. You potentially also need to look at the EU Charter of Fundamental Rights and EU and international treaties. So there are a whole range and a whole body and a profound depth behind you that you can leverage basically when you are arguing what Ireland's Aarhus and AIE implementation needs to be done compared to the FOI Act, which is a national provision, which effectively is free-falling. So basically, if you make a request for access to environmental information, what a lot of people experience is something like this obstacle course here. I don't want to dissuade people from making it, but it's important in the context of the compliance issue that arose in front of the Aarhus Convention. You can run into difficulties with the definition as to whether somebody is a public authority, whether the information that you're requesting is in fact environmental information. You can get hit with costs which may or may not be lawfully implemented in relation to the volume of information and the format of information that you're requesting. You may run into diversions and delays, we need extra time, the dogs can't take my homework, sorry, very understaffed public authorities having real difficulty with responding to your requests, quite genuinely, misapplication potentially of exemptions, failure to weigh the public interest correctly, and you may end up in a situation where you're not satisfied with the answer that you've got and that you may go through an internal review process and you basically can go back around that hoop all over again and you may or may not be happy with the result that you get at the end of it. And if you're not, you have the option to basically take your case further to the Office of the Commissioner for Environmental Information, and now that is an administrative review. And basically the problem ultimately was that this whole process, this whole obstacle course that we have up here on the screen, that can take at least 3 months, if not longer. But basically an authority has up to a month to reply. It's supposed to apply as soon as possible. It's supposed to take into account your timeframes, but it can take a month. If it considers your request is very voluminous or complex, it can say that it needs 2 months. And then at the end of that, if you need to go to an internal review, that takes a month. So you can be looking at 3 months. And then at the end of that, you may still need to appeal. And the issue was when you go to the Commissioner for Environmental Information, you have to stick your hand in your back pocket. You have to take out €50 for the appeal. And you could potentially have to wait 15 months for your decision. Now, if you think about some of the decisions and things and public participation, things that Barty referred to at the start in terms of planning and forestry decisions and things like that, those timeframes are completely and utterly incompatible with a lot of those decision-making processes. And if you need to get additional information in order to be able to make an informed submission, you're gooshed. That's a legal technical term, by the way. So fundamentally, this was the ultimate problem, was how effective was our appeal and how compliant was our appeal system given that, and indeed how compliant was our court system given those issues as well. And that basically led to Right to Know, an Irish NGO, very committed to information and access to information, making a communication, which is the polite word for a complaint, to the Aarhus Convention Compliance Committee, which is an independent body that sits in Geneva, peopled with extraordinarily brilliant legal minds who do this in an entirely voluntary capacity, but who have been appointed by all of the parties to the convention. And indeed, Dr. Anya Ryle, now Professor Ryle from UCC, is the Vice Chair of the Compliance Committee. So that's the number of ACCC 2016141. That is the number of the case, effectively. That URL, you can actually find all of the details, and that gives you sort of a quick look of what everything that you can see. It's highly transparent. You can see the original communication, you can see all of the information, you can see the replies from the state, you can see details of the hearing that was had in Geneva, and you can see the responses and the additional information that's provided. So for those of you who really want to get to grips with it, you can see all of that information laid out there. On the right-hand side, you have Dr. Fred Logue and obviously Gavin and myself, because I acted as an observer, providing information on behalf of the environmental pillar to support the communication and the evidence needed to bring this one home. So this was hugely important in terms of the validity of the whole process for access to information in Ireland, because by the time you got the information, in a lot of instances, it was irrelevant. You had missed the boat in terms of the process that you wished to engage in, or the information was so entirely out of date, and it was effectively undermining the pillar in its entirety. So out there you have the findings in detail, that basically the Office of the Commissioner for Environmental Information was deemed to be non-compliant with Article 9.4 of the Convention because it doesn't provide for a timely procedure, and the courts were also found to be non-compliant because they didn't issue directions for the adequate and effective resolution when they basically were dealing with requests that fell within the scope of AIE regulations, and didn't provide for an adequate and effective remedies. Now, these are quite breathtaking in terms of the implications they have in terms of the timeframes, because it pushes back on the whole system, because it really emphasizes that things have to be timely. And timely is a very rich word, and adequacy and effective remedies are very rich, because if you have a problem, you have to get something that is meaningful for you and relevant for you and of value to you, and that makes sense in the timeframes of the decision process that you're in. So this is quite a complex one to resolve in terms of how Ireland can actually implement a system which is going to be timely and provide for adequate and effective remedies, given the very prolix approach that it has, and given the very under-resourced approach that it has taken to AIE processing right throughout the system, from the request to the internal reviews and right through the OCEI's office, and indeed through the courts. So this isn't an easy, quick fix. And I would think that one of the most sensible ways to actually deal with this is actually to really push the issue of proactive dissemination, so that the issue of requests becomes much more exceptional, and therefore much less onerous for the state to actually have to deal with. But that's some of my own personal thinkings on it. There are the recommendations, but obviously it is ultimately down to the party to what it does, so long as it is ultimately still comes in with compliance. And I look forward to engaging in the consultation in relation to that. Broader obligations, I'm conscious of time and I'm just going to try and skip through this. But I would ask you to go back to that's notes that hopefully some of you might have scribbled or thought about scribbling even mentally, about, you know, how ready you feel to engage with this consultation, your experience of AIE, what you know other people think about it or whatever, and how equipped has the state made you and how has it supported you? Because ultimately what we need to be looking at in this implementation of the regulations is the broader obligations, things like Article 3.1, which says that the state, that basically the parties shall take the necessary legislative, regulatory and other measures, including measures to achieve compatibility of the pillars. Now that's really powerful. Shall take the necessary legislative measures to achieve compatibility, so that if you want information and you want to participate, those timeframes have to be compatible. That's actually a very big thing. To evaluate whether, you know, what are the necessary measures, that implies an obligation to evaluate how well you're doing or how badly you're doing. And we don't do any of that to the extent that I think is necessary. I think we also need to think about the experience of COVID and the challenges that that has, because the Compliance Committee has also said very, very clearly that the convention obligations don't stop during the operation of the COVID pandemic. We just have to get very innovative and very intuitive and very flexible and very accommodating in the way we actually deal with it. And there are real problems in relation to participation and information access consequent on COVID. But we have to respect the timeframes indicated by the requester, and we need greater focus on proactive dissemination. Article 3.2 puts big obligations to ensure officials and authorities assist and provide guidance to the public. Are our officials, in a position to actually do that? Do they do that? Are we measuring that? Are we evaluating it? Are we promoting education and awareness on how to? Do the public actually know how to do this, and are we giving them sufficient help and support? I also think it's important really to ponder on Article 5, the obligations there around collection and dissemination of environmental information. I think this is key, and I think this is where Ireland really needs to make a breakthrough step, in addition to addressing some of the technical failures and confusions in the existing regulations. But we also need to reflect on Article 6 and the participation obligations, particularly around a whole range of consent processes, not just planning as Barty referred to earlier, but also forestry, aquaculture, offshore developments. How do we make information available? Are we meeting the information provision requirements under Article 6 in our consent processes? The approach in new legislation, are we actually heading in the right direction? You might see from the frown on my face, I don't think we are, in terms of things like the climate bill, the Land Development Agency bill, the new forestry regulations. I think we're seeing some very problematic practices emerge in recent legislation. And in relation to plans and programs, do we provide information at the right time and in a way which actually facilitates effective participation? Are our people too compromised in the volumes and the timeframes of information that they have, and their ability to get the additional information that they need in the timeframes for consultation? And in our lawmaking, the approach of, an Attracta schedule being published on a Friday evening, with deadlines for amendments, unclear or within a couple of hours of a bill being published, overlapping with the periods for making amendments between one house and the next, making a mockery entirely of the whole process of passing a bill from one house to the other house. And allowing each house make its mark on it. And is there that opportunity for the public to get the information and to engage in all of that? These are all aspects of access to information that we need to think in a very broad way. And then ultimately there is access to justice. And I have to say, we have to be conscious of the looming threat of the bill to kill access to justice. As it became known, the Housing Planning and Development Bill, it remains in the legislative programme. There is no basis for complacency, I have to say, because sadly I would have to highlight that when the Greens and Fianna Fáil were last in office, they failed to provide for access to justice in relation to AIE. So it is most welcome that they are pursuing this consultation on these regulations, and hopefully it will be a very productive and a very progressive implementation of the regulations. But I would say that there is no basis for complacency, particularly on the basis of what we have seen in legislation thus far. So let your voice be heard. The consultation document is available there. The closing date is 5 p.m. the 16th of April, and there's where you can send your submissions. And thank you.
Fabulous, brilliant, Attracta. Thanks very much. On the final score of getting involved, yeah, absolutely. If people can hear me, that I think that in the chat there is a link now for people to sign up to join with the Just Transition Greens in working on building information and building a submission for this consultation. And I'll just, in 10 seconds, one of the things I think that great kind of potential of the Just Transition Greens is as a force for education, shall we say, you know, that people do learn more about what's going on, for example, with regard to access to information. And to say that in the chat as well, you can put in questions. I saw 1 or 2 have come in already, questions for the participants. So we should have time at the end of all this. Niall, are you ready?
I am ready, sir, yes.
Good man, take over.
I will do. Got my presentation up here for you. Grant, is that up full screen for everyone there?
Yes, I can see it.
Yep.
Grant. Yes, for this we've had, so that's, I guess you've heard more on the theoretical and the legislative and more technical side of it, and probably some of you are wondering what can be the actual practical results out of that. So I suppose I'm going to guide you very briefly through the experience from a journalist perspective of sending the AIE or Access Information Environment requests themselves, what you can be asking for and what you can get out of them, to show you that it does have some very important practical aspects to it. So just very briefly, I know I was introduced at the start, but I'm an investigative journalist with Noteworthy.ie. So we work alongside the journal, but we're a purely investigative journalism platform that is, I think, quite unique in Ireland, that we crowdsource our ideas and then we put out proposals based on them for investigations that are then crowdfunded from the public as well. So I think there's a very good introduction, overview at the start of the model that we have going forward. And I have a background working predominantly on climate and environmental issues, and that's why I've quite frequently used the AIE requests as opposed to FOI. And I think Ciarán sort of pointed out some of the pitfalls at the start there, that FOI can be quite costly and is a lot more powerful, especially by the fact it's underpinned by UN Convention and EU directives. So I think I just want to from the very start, I mean, people, this is sort of the fantasy of an investigator we have, that you become an investigative journalist when you're studying, that you'll be getting all these massive scoops and meeting the best sources in the world in a warehouse or in an underground garage or somewhere like that. But it can happen in some situations. You meet people to exchange documents and things like that. But more the 21st century reality of investigative journalists is a lot of it is desk-based. Especially now during COVID, obviously, I think being an investigative journalist is very much suited to this environment, because a lot of the work you're doing is reading, like a researcher, you're reading a lot of reports, documentation, listening to Oireachtas debates, looking at parliamentary questions, committees, and also, of course, sending a lot of requests. And I think that's where FOI and AI in particular for myself is very useful in the more modern age for investigative journalism. So it was talked about to some extent, there's sort of what sort of information. I know Ciarán gave a good template example of what you would send in terms of, you know, people get a bit scared off, like Attracta said, but in essence, when you go to send an AIE request, you're essentially sending an email, but you're specifying that you are making this request for particular documentation under the Access to Information Environment regulations. Putting in that line ensures then that the person receiving it, the department or the agency, is legally obliged to go look for those records. If they have them, then they're also obliged to release them unless they can specify the exemptions as to why the information cannot be released. So it's fairly straightforward. And for me in my work, and I think this applies across the board in terms of campaigning, but also political work as well, when you're looking for information, the types of records you can look for, it's very broad in terms of the environmental scope. You can look for, you know, documentation, be it internal reports or policy papers on any subject that is related to the environment or climate. It doesn't have to be just emissions. It can be contamination of water, any impact on the elements, essentially. So water contamination, pollution, a range of issues. It can also be things like ministerial briefings about particular issues. That's one that I would quite regularly be requesting. If there's a meeting coming up with a lobby group, you could request the documentation for the briefing that was provided to the minister ahead of that meeting, and it can give you quite good insights into what is being discussed within a department, for example. Tied to that, you can be looking for agendas and minutes of meetings. Another one I would use quite frequently to see, what's going on internally in interdepartmental meetings, but also meetings, like I said, with lobbying groups or elements outside of department, or ministers, meetings between ministers on certain topics, be it around forestry, emissions, fisheries, salmon farming, all these issues. There's a huge range that are covered in terms of their linkages to the environment. You can also be looking, this is one that you quite frequently see quoted in media articles, is correspondence. So you can be, under the AIE you can be asking for lobbying letters that are going into departments or ministers. So I quite frequently would check the lobbying register on lobbying.ie, which gives a very brief synopsis or overview of what information might have been, what lobbying events might have happened, what letters or meetings might have occurred. So they don't give much details, but then you can send an access to information environment request to see the specifics of the lobbying letter. You can look for internal memos that are passed within departments, internal emails to see what staff and experts are talking about internally. That might not be the same thing that is said by the minister in the public, for example. You can look for interagency emails. Like I said, there could be correspondence between the Department of Climate Action and another department, or between the EPA and the National Parks and Wildlife Service, between the Department of Transport and Dublin Bus, for example. So you can look for all those correspondence about particular issues that you're concerned about. And like Ciarán alluded to at the start, you can even ask for text messages and WhatsApp, so long as it is an official departmental or agency phone. It's rare you get them out, but there have been sometimes WhatsApp messages that have come out from requests. Another great thing you can do that I would use quite regularly is looking for data. So one example, you can look for, this is how broad it is in terms of the information you can look for. You can be looking for a cost-benefit analysis about projects, for example, and that should be released. There's a very important case taken a few years ago in relation to cost-benefit analysis for the National Broadband Plan. Long story short, it went all the way, I think, Attracta, if you nod, to the High Court. Am I correct in going that far? Yes. So it was essentially decided at the High Court level that actually that is environmental information, because essentially by virtue of the National Broadband Plan having physical infrastructure to be put in place that will require, transportation, there will be emissions, etc., then the cost-benefit analysis underpinning that project is also environmental. So it's very, very broad, and you could get some of the financial data. In terms of data, you can get information on licenses for forestry, for example, or it could be aquaculture licensing for shell farms or salmon farms. You can get information on inspection rates, for example, investigations. It's more limited in terms of getting information on live investigations, but I have had investigative reports, say, for around forestry from the MPWS or around hedge cutting, released to me once the investigation is closed. And just a whole range of data points you could be looking at. I've received, and I'll go into that in a little bit, over 30,000 data points for forestry, afforestation, felling licenses. I didn't get charged anything from the Department of Agriculture for that. If I did it under FOI, I think, like Ciarán said at the start, I probably would have been hit with a big fee to pay, because there was a lot of data. But under AIE, because you have those underlying principles in the directive and the convention that support, that it shouldn't be expensive, etc., essentially. So, sorry, those very briefly, I know I'm going quite quick now. Those are the bits of information that you can sort of get, and how we've used that. I'll just give some brief examples in Noteworthy investigations. The first one is Spruced Up, which was an investigation into the Irish plantation forestry model that we did last year. We're essentially looking to see what were the environmental impacts and how was the licensing regime essentially monitoring for these environmental impacts. Were they taken into account? Through AIE, like I said, I got over 30,000 forestry licenses released to me with information if environmental assessments were carried out in line with European law or European directives. And also we got information back that have uncovered some of the environmental impacts of plantation forestry and showed that they're still being planted on protected areas, on precious peatlands and other high biodiversity areas without a stringent environmental assessment process being carried out. And all that was only achievable through access to information on the environment, because putting all that information together wouldn't have been possible without getting it released out to us as we did. Another one was the Solving Solar investigation. So this was looking at essentially why Ireland is a decade behind the rest of Europe in the rooftop solar revolution. So we wanted to see what are the policy roadblocks there. So we were able to get access through AIE to the meeting notes, minutes of meetings and reports from this special multi-agency policy group that was, I think there's 5 or 6 departments involved, the ESB, the energy regulator. And it was really revealing because everything on the surface seems to be progressing with the rollout of microgeneration, but behind the scenes, there was a lot of disagreement between different agencies about how much people should potentially get paid for feeding back into the grid, if we should relax planning regulations on the number of solar panels you can put on your roof, just in general, the whole system of how it would be rolled out. So we were able to get an insight into that and get an understanding of the biggest delays, all again through AIE, because publicly quite a rosy picture was being painted of where we were going, but the documents released to us show that we're still quite a good bit away from where we need to be. The most recent one I worked on is one called with Sheer Force, which is about hedge cutting by local authorities during the bird nesting season, which is obviously going on at the moment. So we wanted to see to what extent hedges were being cut during this period when you're not supposed to, how much was being paid, and essentially what was the justification. So we got the inside details on the hedge cutting tendering process, that the councils were putting out the contractors that showed they were essentially 90% in favour of cost and very little towards environmental protection within the tendering process. So essentially was the cheapest you could get was the way the councils have been doing it for many years. We were able to show about 3,000 kilometres were cut over a 3-year period on behalf of the councils during the bird nesting season, predominantly for road safety issues. But we were also able to show through the documents that were released to us and through the data that was released that there was no real assessment process before and after the cutting was taking place to determine that road safety issue. And another interesting one, like I said, we got documentation on prosecutions and investigations taken by the National Parks and Wildlife Service about cases of illegal cutting. So that information, I mean, there was some news reporting on individual prosecutions and cases, but we actually got the data on all the prosecutions, the fees that were implemented over the last 10 years or so. So all that wouldn't be possible with AIE. This is the sort of information that isn't publicly available that I would say probably should be, but that you have to go searching for. And AIE, I would say, is really the best way to get that information out, especially for a news story. I have a few minutes left, so I'm very quickly going to go through some case studies, which were more my first foray, I guess, into AIE a few years ago. The first one was looking at Bhroin's biomass importation. This was the co-fire with their peat-fired power plant in Eden Dairy. I guess at the time, this would have been 2014, I started looking at this. We knew that Bhroin were importing a biomass linked to the palm oil industry. There's these things called palm kernel shells. They're essentially, that's what they are. They're the shell of the palm, the kernel of the palm. We didn't, that was all. Like, there was essentially, if you Google it, there was absolutely nothing available online about it. Like 2 or 3 Google hits on what a palm kernel shell was, nothing about Bhroin. But I did know that the palm oil industry has been known to be quite unsustainable. So also another thing, we knew that much, but we didn't really know is how much biomass was being imported by Bhroin. None of that was publicly available. All that was said was that The company was, the biomass was carbon neutral. You can argue what you want about that, but nothing more. We certainly didn't know if they were using sustainable sources. So that was the crux of my AIE request. I essentially said, under the access to information, the environment request, I want to know how much of this stuff you're importing, where it's coming from, the sustainability certifications for each import. That was essentially what I was looking for. And out of that, the information that came back from Bord na Móna showed the scale of the imports, how much they were importing per year, from which companies, from which countries. Most of it was coming from Indonesia, where we know there's a lot of issues around the palm oil industry, ironically being planted on peatlands over there, for what would now be described as former peatlands because of the plantations on them, to supplement the burning of peat here in our own country. It's quite ironic there. Also was able to show that Bord na Móna knew it was unsustainable, and that they hadn't verified the sustainability of the sources at all. So very quickly, you can see here, that is the response that's a copy of the response I got. It's quite small for you to see from Bord na Móna, but I didn't actually get back what I was asking for. I was asking for documentation to show that the importation, the palm kernel shells were imported from certified sustainable sources. But that was the answer. I didn't get an answer which was the answer, which was that Bord na Móna hadn't requested any information to confirm that it was sustainable. So I didn't get what I wanted, but the answer essentially told me what I was expecting to see. And then I actually, funnily enough, I didn't get an answer for a report that I wanted from Bord na Móna about sustainability, but I knew they had sent it to the Department of Climate Action. So I also made the same request for the document to the Department of Climate Action, who, thankfully enough, gave the document in full to me. So in that document, Bord na Móna very clearly said that they were aware that these plantations are grown in former peatlands with very high carbon dioxide emissions, and that in the future it looked like the importation of these palm kernel shells will be ruled out by sustainability criteria coming from Europe. So publicly saying the biomass was sustainable, but telling the Department of Climate Action that they knew that there were high emissions coming from this industry where they were getting this byproduct from. So again, like I said, none of that publicly available. Bord na Móna are not open to FOI, but they are open to access to information in the environment. And that was the only way I could have got this information out. And that led to a big expose in the Irish Times, after which Bord na Móna determined that they were to stop importing palm kernel shells completely and change their process in terms of monitoring for the sustainability of the biomass they're importing. And sorry, I'm at my alarm going off at 17 minutes, so I have about 3 minutes to get through this last one. So this is the second one. This was kind of a continuation. This is about, again, a big semi-state company, the ESB, looking at their coal importation. So I followed this on. I thought, well, why don't I look at others as well and see for similar things? I knew that ESB were importing coal from Colombia. There was, I think, an Irish Times letter from about, I think, the early 1990s complaining about it. But otherwise, there was very little about where the coal used that money point was coming from. What I did know from some quick Google searching was that Colombian coal mines have been associated with several issues, including, obviously related to climate, but also water contamination and human rights impact on indigenous communities. What we didn't know in the particular case of ESB was how much coal they were importing and from where, and again, was it sustainable or ethically sourced? Because I knew quite clearly that if I could determine where the mines, which particular mines the coal was coming from, that information then on the particular mines, there would probably be information online from, previous reports from NGOs linking it to potential environmental or human rights issues. So I made a very similar request to the Bord na Móna one, asking for data on the on each importation, from which company it was coming from which mine, if there were intermediaries, how much, internal documents, and internal meetings, internal emails about any concerns they have over human rights issues linked to the coal imports, environmental issues related to the coal imports. And I did several requests, and then out of that, I got a lot of information. I got all the importation records, so I was able to see the scale of the imports, the origin, which companies, which particular mines it was coming from. I was able to see that there's actually an Irish company who was marketing all the global exports from one particular mine, the Ciarán mine, where the most of the coal that's been used at the ESB mine is coming from. And I don't think anyone, I didn't even realize that myself. It just came back in the documentation that this company kept on repeated again and again. And I Googled them and saw that they're have their headquarters in Funballylane in Dublin. And I also saw that ESB were particularly concerned over time about the media reporting. So once this story sort of broke, I sent more requests to see how they had reacted to it through AIE. And the main concern that seemed to be coming out was over the actual media reporting itself and the image it was presenting of the company, which I was quite surprised with. I thought there would have been more of an emphasis on this. We need to look into this. Eventually, yes, they did take a greater look at this. So that's just an example to show from the requests, the data that came back. I was able to see which mines. You could see the majority coming from the Ciarán mine in Colombia, which is, again, like I said, a quick Google search then would show that there's been several issues linked to that particular mine, that particular company. Again, all it took was the AIE request to show where it was coming from, and then Google, talking to NGOs, talking to experts, does the rest of the story for you there. But it wouldn't have been possible to get this information unless I used the AIE request to get it. It's not publicly available. ESB were not going to tell me publicly. I tried, and you can try and press requests, but you're not going to get this level of detail. And again, ESB, they fall under FOI, but it's very, very limited to more technical grid-based information. Nothing like the level of detail you can get through AIE on environmental matters. And this story wasn't just about breaking the story. I mean, this information was actually, it's been used quite widely. It's been used in the Dáil. It was taken on by Sean Crowe quite early from Sinn Féin, raising a lot of questions about the sourcing of coal. So it's on the record of the Oireachtas now as well, the information. It's been used by several NGOs. Because an important point to mention is once something is released through AIE, it is in the public domain. So, I mean, for me, of course, there's certain information I will want to keep for my stories and investigations, but there's also information that you can share more widely with the public to see if it's of interest to other people. So my data was taken on by several NGOs, environmental NGOs, but also human rights NGOs. One of them, Christian Aid Ireland, has recently referred the ESB to the OECD for alleged breaches of human rights for importing that coal from the Ciarán mine due to to the allegations against it of human rights issues. So, I'm very proud of the investigative and the journalistic side of what I did, but also the fact that that story has gone much wider. And again, like I said, all of it started from a very simple email saying, I want you to give me X, Y, and Z bits of information under AIE. Very kindly, like Ciarán said, please, if you need to give me a call, we can discuss things, blah, blah, blah. But there you go. And that's how it starts, a simple email. But like I said, when you're putting in that it's under the AIE regulations, you're making the request, there is the legal obligation then to search for that information, retrieve it if it's there, and give it to you unless you can provide for the very clear reasons why there's an exemption that it can't be released. And I would argue that, information is on your side, that the ruling, in principle, as I think Attracta said, in principle, it's on your side, but maybe in practice, the decisions don't always go your way. So very quickly, I am 1.5 minutes over my time, I'm sorry. The good parts that I was particularly found about AIE, from the journalist perspective, sending multiple requests over the years, is it really does give that access to wider context on stories or projects that you might be working on. And this applies as a journalist, but also as a researcher, as an academic, as a campaigner, as a politician. I mean, it's a great tool. I've used it in my personal capacity because I have the wonderful luxury of living in rural Kildare with lovely countryside, but also with about 5 quarries very close to me. So I've sent several requests in a personal capacity about licenses for the quarrying, about planning issues, And I've got some very revealing documentation back as a citizen as well that I can use when I'm putting in, say, appeals against planning decisions, for example. It has wider agency access, like I said, than the Freedom of Information request. All semi-states should be and agencies should be falling very broadly under AIE. There are some arguments going on now about semi-states of the likes of ESB and Board and Mona. I think that has been settled to an extent, and I think it'll be settled very, very soon in the favor that, you know, subsidiaries of semi-states should also very clearly fall under AIE. So it's definitely less restricted than FOI. And like I said, and like Ciarán and Attractive said, it's underpinned by UN and EU, UN Convention and EU directives. So that really gives it the strength that the FOI doesn't have, which is just national. The bad, I'll just very quickly say, a lack, and this has been talked about before, a lack of knowledge of AIE within certain agencies and departments and councils is not helpful, because you'll often find, despite putting that disclaimer that Ciarán said that this is not an FOI request, I still find that sometimes it's treated as an FOI and dealt with under, which is obviously completely wrong. But I think that's a lack of training and a lack of knowledge within certain agencies and departments. And linked to that, the use of exemptions under FOI to deny your requests. Some of them are linked if you look at the regulation and the act, but I mean, sometimes it's just directly taken from FOI, which doesn't apply to AIE. And the very ugly parts that I've seen from my experience is the use of extensions on a regular basis, even for very limited requests. So the department or an agency can ask for, beyond the initial 4 weeks, can ask for an additional 4 weeks if your request is deemed quite voluminous and takes a lot of time and effort to reply. That's perfectly acceptable in some cases, but honestly, I've had extensions where I'm looking for literally one document and I've said exactly the document I want. So I think there's arguments to be made there. And also the fact that there is a 4-week deadline. It's supposed to be answered as soon as possible, but I think Attracta and Ciarán will say the same. But you wait till the deadline day to get an answer. It's very rare you'll get before. Sometimes genuine, of course, but sometimes you feel if you have a very strict, very limited request, you could get an answer after a week if you're looking for literally one email or one document. Refusal of records is non-environmental. I think the definition of environmental information is very broad in the regulations, but I have had refusals for requests related to coal refused as being non-environmental, as an example. So it does happen, and you have to argue back. But I mean, you could get a refusal on the last day and you've wasted 4 weeks of your time. And like that's obviously been discussed, and is a big part of why this consultation has been called, is that the appeals process, when you go to the Office of the Commissioner for Environmental Information, is far, far too long. I've waited up to 12 months, I think maybe over a year once or twice, you know, where you actually forget about it, and then you get a letter in the post telling you, here's the result. And you're like, oh yeah, I forgot about that one. So it takes far too long to get an answer. As a journalist, you know, as a news journalist, you're not going to be relying too much on this, but as an investigative journalist, that can halt or slow down an important part of the investigation. But also from a legal perspective, I know this is used as a tool for court cases around the environment. So a delay in an appeal for up to a year can have a big impact, and you might get a decision in your favor too late when you needed the document 6 months ago. So there's big issues with that process that really has to be changed. But sorry, I went 5 minutes over, but that's it from me and my experience as a journalist using the AIE. I will stop sharing my screen as well.
Lovely.
There you go.
Thanks, Niall. That's great. Really interesting stuff. I think actually we're out. Like I think we promised people we were going to finish at 8:30. So I think we're going to have to go without questions. Am I right, Claire? Like that we promised everyone 8:30 was the closing time. But
if the panel are willing to stay on.
Yeah, I'm okay to stay for a few questions. For a couple
of questions. In that case, I would like there are a couple of questions have come in, but I don't want to force people to Attracta and Ciarán if you have things to, like we promised you 8:30. So
no, you're grand. I'm multitasking with votes in the European Parliament on another screen, but I'm happy to stay on for a few questions. It's kind of I'm following a line here.
in that case, I'm gonna start off with a question for Attracta, which came in and which I was interested in myself, was and it goes to a point that Niall was just making about delay, obviously. And one of the things that, and this goes to the consultation process, specific changes. One of the things is that in the process, you make an appeal to a public authority. They can say no, and then, or you look for information from public authority. They can say no. You then appeal to them, and they have a month to reply. Then you go to the office of the Commissioner for Environmental Information. Could we just get rid of that moment of appeal to the public authority, so that and just go straight from refusal from the public authority straight into the office of the Commissioner of Environmental Information? And that would actually speed up the process.
Well, I'll just say very briefly, definitely no.
No.
Just from my experience, internal reviews, I'd say about 75% have gone in the favor of, in my experience, of the initial decision. But I have had some cases where the decision has been different. So the internal review is essentially the decision is looked at again, 4-week period, looked at by a superior officer within the agency department. And yeah, I have had cases where they've said, look, that wasn't looked at correctly. You should be released X, Y, and Z document. So I think it's a much better process because you don't have to put in a lengthy submission attached. You can just say, I want an internal review. You don't have to say why. You can specify if you want, but when you go to the OCI level, you have to put in a fairly detailed submission. And like we said, look, you're looking at minimum 3 months, probably longer to get an answer back. And if your request was refused and the OCI say, okay, it should be looked at, it should be released or looked at again, you can go through a process of another month, maybe, if the request been looked at again. So I think the internal review process is a better process, although in my experience, you often don't get the answer you were looking for.
Attracta, what do you think? I actually want, because I know in the discussion in Geneva the last time, one of the things is that one of the reasons Ireland gets away with having such a long appeals process afterwards is that internal review is quite quick. It's only a month. And so then afterwards, they can say, okay, that actually meets the timeliness issue. And afterwards, the OCEI can take, a year to come back. But we've already had this kind of quick internal review. Therefore, it's okay. And I actually wonder, I don't know, maybe Attracta, you agree with Niall that we should leave it as it is? Attracta, I can't hear you. No. Oh, bummer.
And that might be an opportunity just to bring in Alison Ho. I know she had a question and would like to publicise an event.
Alison Hawk, yeah, that'd be.
Sorry about that.
I know you're grand. Yeah, so I'll resist the temptation to make a joke about that, but yeah, no, I just had a question about the issue of threshold refusals, which was raised in the decision from the ACC by Right to Know, and basically the allegation was that there's a practice of refusing requests on these kind of what are called threshold issues, so whether it meets the threshold for an environmental request or not. So, is the information environmental information? And that wasn't accepted by the committee. They didn't make a finding on that point because they said their evidence hadn't been presented that while there was evidence that there was a large number of refusals, there wasn't evidence that those refusals were wrong. So I was just wondering, I'm an academic, I'm a lecturer in AIT, but there's loads of people here who have lots of practical experience of making AIE requests, and I'm just interested from that practical point of view. Do you think that there is a kind of a systematic practice of just saying no, and given that as the reason it's not environmental information and it not being kind of genuine, or is it the case that, generally speaking, public authorities engage in a genuine fashion with the request at the very first stage?
Not sure if I can be heard, can I?
You're back now. Yeah.
Oh, sorry about that. I don't know what happened. Must have been just a loose connection there. do you want me to try and answer both of those questions now, Barty? Well, first of all, I have to disagree with you in relation to just the interpretation of what the findings were, because ultimately the issue wasn't that Ireland got off because of the short internal review period of a month, which is actually prescribed in the AIE directive, but the issue was that Ireland was found that it hadn't complied with the characteristics of the review, of the independent and impartial review that was undertaken by the OCEI's office. So on the grounds of timeliness, and those characteristics apply to all of the review considerations. Because there was a lot of discussion, a lot of very technical legal discussion as to whether what part, you know, basically how was the review that happens at the OCEI's office, in which paragraph did it fall? Was it paragraph 1 or paragraph 2? And we could be here all night just explaining that. But the point was made very strongly in the hearing that notwithstanding whether it fell within 9.1 or 9.2, 9.4 and the characteristics apply, and that's why Ireland was ultimately found in breach. And if you look at the actual findings, it was the failure to comply with 9.4 on timeliness was absolutely key. On the issue, I suppose, of the internal review, like Niall, I actually think it's important for authorities in some respects to have a chance to self-correct, and I have found on occasions that there has been a reversal. I know others would basically argue that it's just a case of, you know, just that they find it just to be, you know, inevitably that the original decision is going to be upheld. But you have to think about what would happen basically if everybody went from sort of first review and everything just went straight to the OCEI's office. You know, would you just effectively be moving the bottleneck to one authority to decide all of the different internal reviews coming from all of those different authorities? So you would actually have a bigger bottleneck arising at the OCEI's office and a bigger staffing requirement, and there is the charge that is levied on that, and people may feel a little bit more intimidated about going to that. I think there is an issue of timeliness. I think there is flexibility in the directive to look at the way we actually construct the different tiers and levels, and I think it is worthwhile looking at it and evaluating with the OCEI's office and the department, you know, what is feasible here? What is Ireland's ambition in terms of the types of timeframes and the flexibleness of its response on this? On the threshold jurisdictional point, it's a complex issue in terms of the evidence. I think it's always a hard one to make a determination of. Obviously, we're all human beings and we all have our suspicions. But I think the issue could probably be best be dealt with if there was a much more rigorous approach to a thorough evaluation of who is a public authority, what is environmental information, a rigorous requirement that authorities produce the registers of information associated with their functions, which they should provide. And I think that would avoid a lot of the issues that we end up with, people dithering over whether something is or isn't environmental information. I think a lot of more proactive, robust approach to implementation could avoid a lot of those issues and the confusions and the frustrations that can arise for all parties, you know, both on the public authority side and indeed on a requester side, consequent on those threshold jurisdictional issues. But it is a vexed one, and I'd be interested in your own thoughts, Alison, on it, to be perfectly honest. An expert like yourself might come up with very interesting insights on it, so thank you for that.
And thanks, Attracta. Yeah, no, I think you've hit the nail on the head there. It's about the, you know, specificity of the definitions in the legislation, and I think they need to be nailed down. I haven't come to the stage of deciding how exactly you would do that, but it would be interesting to kind of, you know, maybe to brainstorm on that at some stage as well.
Yeah, but I think it even goes further than just the legislation. I think it's the obligation of public authorities to basically keep clear registers of what is their environmental information.
Absolutely.
You know, and you know, then everybody, you know, that can be dealt with, you know, on a systematic level rather than on an individual request level, you know. So
yeah, I just might add there, Alison, I think you were asking also about how is there potentially a systematic issues in how it's handled? And if there's genuine efforts, like most of the officers that probably, I think Attracta you would say the same, like most of the officers you deal with handling your requests are quite helpful from off the bat, at least in my experience, that a lot of them are engaged in the process. They're interested in transparency. They want to help you try to refine your request if necessary, to rejig this or that, because sometimes even when I think I'm asking a very specific request, they might say, well, look, there's actually like 500 documents potentially here, so maybe we can discuss how you can refine. That can be very helpful. But in other cases, I've dealt with officers who very, very clearly do not want to help. Like it is a handful, but it shouldn't actually happen. There should be a uniform training process in place to ensure that whoever's in charge, and there should also be, I would guess, a quite simple complaints process that you can make. Like I just find there is no real remedy if I have an issue with an officer that I can clearly tell they're trying to block releasing information. I have documented one case in my own council where they've essentially, well, not essentially, they did lie to me in their answer, saying that the information was available and we put up on the planning website, and then it turned out through a subsequent planning notification or enforcement action that those documents were never provided them in the first place by the quarry in question. So there's no real proper remedy process to go through. So I think until that happens, you're going to have the odd case here or there where you have someone who just is trying to block releasing the information, and there's no real ramifications or repercussions for that.
I think that's absolutely fundamental. I couldn't agree with you more, Niall. If I can just jump in there, because effectively, if you've been subject to a really unacceptable experience, you know, through the request process and the internal review, your only recourse then is actually to stick your hand in your back pocket and pay €50, and you're not even going to get the information in a meaningful time frame, and you won't actually get a recourse or remedy, or there's you know, a limited remit for the OCEI's office to actually take any sort of proactive approach to the failures of that public authority in terms of its future handling. And I think you know, if we're really looking at taking all measures, we actually need to have self-correction, self-monitoring, and that's what I meant earlier when I said, you know, necessary implies evaluation. And if we're not even tracking where we're failing and where we're messing up, and the burden is constantly coming back to the same sets of individuals, and the wider public is just being discouraged, then we will not make progress.
Okay, I think we're going to have to close up now. Let people go home.
Before you do, I was just wondering if I could get a plug in, just because Ciarán mentioned it earlier on about the Aarhus Regulation amendment that's happening at EU level. And obviously it's very relevant in a way because it applies the same requirements as the AIE regulations do, only to EU bodies. And I'm working with the EJNI, which is a network of researchers and NGOs on the island of Ireland. And we're having a day of action on the Aarhus Regulation Amendment to raise awareness of it next Tuesday, the 30th. So I'm just going to pop the link in the chat there just for people to kind of spread the word on it, if that's okay. Sorry.
Absolutely, yeah. And actually a question came up earlier on. Somebody was asking about how this operates or doesn't operate in the north, you know, whether we have the same crossover. So I guess that's going to be a topic for discussion.
Yeah, I mean, you know, your whole Brexit, you know, maintaining similar standards between north and south, the Aarhus Convention is really relevant to that, because at the moment we do have the same sort of similar set of rules that have been implemented through EU implementation of the Aarhus Convention. But going forward, we'll be looking directly to the Compliance Committee to assist with maintaining that level playing field of similar environmental rules in Northern Ireland and Ireland. So yeah, it's kind of, yeah. Okay. Don't get me started on that.
Maybe if I could just have a last quick word. I just asked our advisors in the Greens European Free Alliance group for a note from them on what they see coming up at European level. And they are saying, look, the revised Aarhus regulations from 2020, they're being negotiated in the ENVI, the Environment Committee, one of the 20 committees in the European Parliament. Grace O'Sullivan actually sits on that. But in a nutshell, 2 points that the Greens will be making. We want to extend the possibility to challenge acts and omissions by EU institutions and bodies that contravene EU law relating to the environment to all members of the public, number one. And secondly, we want to extend the scope of the regulation so that all European Union administrative acts can be challenged. So that would bring in binding, non-binding agreements, things like state aid decisions. This is a hugely important issue, not just for Ireland, but France. It kind of feeds into the big rows about tax and who's getting the tax breaks in other countries, not just our own. So we will have a pretty intense discussion about it at European level over the coming months. And feel free to contact either Grace O'Sullivan or myself if you have any thoughts or concerns. And so that's a quick European view from my end.
Fabulous, thanks.
Can I just jump in?
Absolutely.
No, just I've answered some of the questions there from Mary McGuigan and from Patrick Ronda there privately. I hope that's enough for them. I just one in relation to, I saw Oscar Mooney was asking about trying to get disaggregated carbon emissions down to the company level from, the EPA obviously have the sectoral. Could you use FOI or AIE to request this information? I don't think you can. I've tried it. I'm currently working on a project that will be finished up soon, which is trying to look at the emissions from the largest companies in Ireland, individual company level, including from the agri-food sector. And yeah, you're not going to get the disaggregated information. I've tried through SEAI, through the CSO, through the EPA, unless it is provided as part of the European emissions trading system, or there's a few other bits of regulation, you're not going to get the information. So I probably wouldn't expect that you'll get the information there, but I hope potentially, Oscar, you could send me an email, because hopefully a lot of the information you're looking for will be in the cost of carbon investigation that will be coming out hopefully next month. That was a cheeky plug as well at the same time.
All right. Any other plugs? Absolutely. Go for it. Anybody? Otherwise, I'm going to close up. Just to say, really, thanks to the speakers. Really, really interesting contributions. And thanks to people who asked questions. Unfortunately, we didn't have time for too many. Let me see what else. Please do get involved and fill out the form in the chat if you're interested in other events. We are going to be working on this now within the Just Transitions. Trying to get our heads around this consultation, what's involved, how can it be improved based on what we heard tonight, and then thinking about it ourselves again. So, the more people who are willing to get involved and do a bit of thinking on this, the better. So please do. And I said it before, and I think one of the great things about Just Transition is encouraging people to find out more about this kind of stuff for themselves, really. And this is just one instance of it. There will be other things happening again that Just Transition will be working on, submissions or policy issues or other topics coming down the road. So I think you can probably find an email address for Policy Officer Claire Fitzgerald or Sean McCabe, get in touch with them or fill in the form. Thanks to everyone for coming along. Thanks to Ciarán, Attracta and Niall for really interesting talks. Thanks to Alison. Unfortunately, we didn't get you to get a chance to hear you talk longer, and we'll have you back another time. Seriously, book it. And thanks everybody. Thanks to organisers, and I'll talk to you soon. All right. Good luck. Bye bye.
Thanks everybody. All the best.
Thank you.
Thanks, Attracta.
Thanks, Bertie.